Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. There's a bill working its way through the Parliament that presents a clear and present danger to the free and open internet, to freedom of expression, and to privacy online. It's a private member's bill that shockingly has gotten traction. You may have heard of it thanks to Professor Michael Geist, who has called the bill the most dangerous Canadian internet bill you've never heard of. In a nutshell, it will require any website on the entire global internet that makes sexually explicit material available to verify the age of anyone who wants access to ensure that they are not under the age of 18. Keeping sexually explicit material away from kids sounds like a laudable goal, and one that I think that most people can get behind. The devil, as they say, is in the details. It presents a real risk to privacy, a real risk to freedom of expression, and a real danger to the open internet in Canada. The author of the bill says it does none of that, but I believe she is mistaken. The bill was introduced in the Senate of Canada in November 2021 by Senator Julie Miville-Deschênes. She's an independent senator appointed by Prime Minister Justin Trudeau in 2018. Much of her career was spent as a journalist, which makes her obliviousness of the freedom of expression impact of her bill really puzzling. I don't think she's acting in bad faith, but I think she's mistaken about the scope and the ultimate effect of her bill. In 2022, the bill was considered by the Senate Standing Committee on Legal and Constitutional Affairs. That committee reported it back to the Senate in November 2022, and the bill languished until it passed third reading in April 2023 and was referred to the House of Commons. Many people were surprised when the House voted in December 2023 to send it for consideration before the Standing Committee on Public Safety and National Security. Every Conservative, Bloc, and NDP member present voted in favor of this, while most Liberals voted against it. Suddenly, the bill had traction and what appeared to be broad support among the opposition parties. So what does the bill do and why is it problematic? Well, let's go through it clause by clause. The main part of it, the prohibition in the offense, is contained in Section 5. It creates an offense of making available sexually explicit material on the internet to a young person. This incorporates some defined terms from Section 2. So making available is incredibly broad. When a definition says includes, it means that it can mean more than the terms that follow. Transmitting is itself a very, very broad term. Is that intended to cover the people who operate the facilities over which the porn is transmitted? It is, as I said, very broad. A young person is a person under the age of 18. That's pretty clear. Now, the definition of sexually explicit material is taken from the Criminal Code of Canada. It should be noted that this definition was created and put in the Criminal Code for a particular purpose. This is not a catch-all offense that makes it illegal to make sexually explicit material available to a young person categorically. This is an element of an offense where the purpose of providing this material to a young person is to facilitate another offense against that young person, or I guess another young person, essentially grooming a young person. To be clear, it's not a crime to make this sort of material available to a young person unless you're planning further harm to the young person. Let's look at what is included in this definition. Visual, written, or audio depictions of explicit activity, and visual depictions of certain body parts or areas if it's done for a sexual purpose. In paragraph 5A1, it does not say that the depiction itself has to be explicit. It says the activity in which the person is engaged is explicit. Let's take a moment and let that sink in. This is not limited to porn sites. This sort of material is broadcast on cable TV. It's certainly available in adult bookstores, which specialize in certain types of publications, but it's also available in general bookstores. This sort of material is available in every large library in Canada. This definition would include educational materials. The definition is so broad that it covers Wikipedia articles related to art, reproduction, and sexual health. It is certainly not limited to materials that would solely cause a reasoned risk of harm to a young person, and it doesn't take any account of the different maturity levels of young people. The sex ed curriculum is very different for 14-year-olds, 16-year-olds, and 18-year-olds. Section 6 is where the government-mandated age verification technology comes in. Essentially, you can't say that you thought you were only providing access to the defined material to adults. You have to implement a government-prescribed age verification method that is supposed to ensure that the people getting access are not under 18. That's essentially the only due diligence defense here. Now, we'll talk about the government-prescribed age verification methods shortly. There's also another defense, which is legitimate purpose. It says, no organization shall be convicted of an offense under Section 5 if the act that is alleged to constitute the offense has a legitimate purpose related to science, medicine, education, or the arts. Maybe that will be interpreted broadly so that Wikipedia articles related to art, reproduction, and sexual health are not included. But it's a defense, so it has to be raised after the person is charged. The onus is on the accused to raise it, not on the prosecution to take it into account at the time of laying a charge. There's also a defense that's available if the organization gets a Section 8 notice and complies with it. Well, what the heck are those, you may ask? The bill has an enforcement authority, who I'm afraid will be the CRTC. CRTC porn police, maybe. If they have reasonable grounds to believe that an organization committed an offense under Section 5 by allowing young people to access explicit materials, the enforcement authority may issue a notice to them under this section. The notice names the organization, tells them they have reasonable grounds to believe they are violating the act, but they don't have to tell them the evidence of this. And they essentially get to order the organization to take, quote, steps that the enforcement authority considers necessary to ensure compliance with this act. It doesn't say that are necessary, but what the enforcement authority thinks is necessary. So the organization has 20 days to do all the things specified in the notice. They do get to make representations to the enforcement authority, but that doesn't stop the clock. The 20 days keeps ticking. Now here's where the rubber hits the road in this bill. The enforcement authority, if they're not satisfied that the organization has taken the steps that the enforcement agency deems to be necessary, the enforcement authority gets to go to the federal court to get an order essentially blocking the site. Specifically, it says, quote, for an order requiring internet service providers to prevent access to the sexually explicit material to young persons on the internet in Canada, unquote. Any internet service provider who would be the subject of an order would be named as a respondent to the proceedings and presumably can make submissions. But I can only think of one or two internet service providers who would do anything other than consent to the order. Take a look at this section which sets the criteria for the issuance of an order. It says the court must issue the order, not may, but must, if there are reasonable grounds to believe that the organization committed the offense under the act. It doesn't require proof beyond a reasonable doubt. It doesn't even require proof by a civil standard, which is on the balance of probabilities or more likely than not. And it doesn't even require actual belief based on evidence that an offense actually was committed. It requires only reasonable grounds to believe. And it requires them to have not taken all the steps dictated by the enforcement authority within the extremely brief period of 20 days. Those measures might have been unreasonable, but they don't get a chance to challenge it. Finally, the order must issue if the court determines, quote, the services provided by the internet service providers who would be subject to the order may be used in Canada to access the sexually explicit material made available by the organization. Wow, that is a really, really, really low bar for taking a site off the Canadian internet. But wait, there's more. The Act specifically authorizes wide-ranging orders that have the effect of blocking material that is not explicit and also barring adult Canadians from seeking access to that same explicit content. And if you look at the first sentence of subsection 5, it says, quote, if the federal court determines that it's necessary to ensure that the sexually explicit material is not made available to young persons on the internet in Canada. It doesn't say anything about limiting the continuation of the offense or even tying it to the alleged offense set out in the notice. This is really, really poorly drafted and poorly constructed. So as we've seen, all of this hinges on companies verifying the age of users before allowing access to explicit material, and the only substantial defense to the offense set out in the Act is to use a government-dictated and approved age verification method. We need to remember, adult Canadians have an unquestioned right to access just about whatever they want, including explicit material. The criteria for approving an age verification method may be the only bright spot in this otherwise dim Act, and it's only somewhat bright. So before prescribing an age verification method, the government has a long list of things they have to consider. Specifically, it says the governor and council must consider whether the method A, is reliable, B, whether it maintains user privacy and protects user personal information, C, collects and uses personal information solely for age verification purposes except to the extent required by law. What law? Okay. D, destroys any personal information collected for age verification purposes once the verification is completed. And E, generally complies with best practices in the fields of age verification and privacy protection. Remember, they just have to consider these. They're not must-haves, but good-to-haves, and there's no obligation on the part of the government to seek input from the Privacy Commissioner on whether any of these technologies work in a privacy-protective manner. So what is the current state of age verification? It's not uncommon to require a credit card under the assumption that a person with a valid credit card is likely an adult. I'm not sure that's the case anymore, and also I don't think it may be necessarily reliable enough. There's also ID verification, often coupled with biometrics. You take a photo of your government-issued ID, take a selfie, and software reads the ID, confirms you're over 18, and compares the photo on the ID to the photo you've taken. Now that involves collecting personal information from your ID, which very likely includes way more information than is necessary to confirm your age. It also involves collecting your image, and it involves collecting and using biometrics from your selfie and your ID. Do you really want to provide your detailed personal information, that sort of information that could be readily used for identity theft or fraud, to a porn site or to a third-party age verification service? One scheme was proposed in the UK a number of years ago, in which you would go to a brick-and-mortar establishment like a pub or a post office, show your ID, and be given a random-looking code. That code would confirm that someone reliable checked your ID and determined you were of age. Of course, this becomes a persistent identifier that can be used to trace your steps across the internet, and I can easily imagine a black market in ID codes emerging pretty quickly. And there are some important things missing. For example, is it universally applicable? Not everyone has a government-issued ID. Some systems rely on having a valid credit card, and not everyone has one, let alone a bank account. The bill's sponsor and supporters say smart people will come up with something that's reliable and protects privacy. Why do we have to wait until we have that before considering passing a bill like this? We should hit pause. So let's game this out with a hypothetical. Imagine, if you will, a massive online encyclopedia. It has thousands upon thousands, maybe millions of articles, authored by thousands of volunteers. These articles cover the full range of subjects known to humanity, which of course includes reproduction and sexual health. A very small subset of the content they host and that their volunteers have created would fit into the category of sexually explicit material. But it's there, it exists, and it is not age-gated. The operators of this encyclopedia very reasonably take the view that their mission is educational and they're entitled to the protection of the legitimate purpose defense that is supposed to protect, quote, science, medicine, education, and the arts, unquote. They also take the view that providing access to their educational material in Canada is protected by the Charter of Rights and Freedoms. And they also reasonably take the view that the Charter protects the rights of Canadians to access the content they produce. This is absolutely right. That's the way the Charter works. But one day, a busybody complains to the CRTC's porn force that this online encyclopedia contains material that may be sexually explicit. The captain of the porn force drafts up a notice under Section 8, telling them that they must make sure that only people who have confirmed their age of majority via a government-approved age verification technique can get access to explicit content. The encyclopedia writes back and says, hey, please let us know what is your criteria for judging whether something is published for a sexual purpose, as required in many parts of the definition. We don't do that. Also, they say their purpose is entirely educational, so they have a legitimate purpose defense. And they also mention the Charter. Now, meanwhile, 20 days pass by. So the porn force make an application in the federal court, and they serve notice on all the major internet service providers. None of those ISPs show up at the hearing. The publishers of the encyclopedia hire a really good Canadian internet lawyer who tells the court that the encyclopedia's purpose is legitimate and related to education. And also, they're likely not engaged in commercial activity. And, the lawyer says, cutting off access to the encyclopedia would be unconstitutional as a violation of the Canadian Charter of Rights and Freedoms. The government lawyer, on the other hand, on behalf of the Porn Force, points to Section 9, Sub 4 and says to the court it does not have discretion to not issue the order if there are reasonable grounds to believe an offense has been committed and they didn't follow the dictates set out in the Section 8 notice. So even with the encyclopedia's information about the purpose, the bar of, quote, reasonable grounds to believe is so low that paragraph A is met. Since the encyclopedia didn't follow the Section 8 order because they were sure they had a defense to the charge, paragraph B is met. And of course, an order to all Canadian ISPs to block access to the encyclopedia would have the effect set out in paragraph C. That is what we call a slam dunk. The court must issue the order. But what about the fact that it would have the effect of cutting all Canadians off from the 99.999% of the site's content that's not explicit? Tough. Paragraph 5 of Section 9 says, yeah, that's okay. No encyclopedia for you. A charter challenge would then be raised, and the whole thing would likely be declared unconstitutional as a violation of Section 2B of the Charter that can't be justified by Section 1. So in short, even if you think the bill is well-intentioned, it's heavy-handed, poorly constructed, doesn't take freedom of expression into account, and imagines that we can manufacture some magical fairy dust technology that will make the obvious privacy issues disappear. In short, it's a blunt instrument that imagines it'll fix the problem. And I should note that it will likely also have the effect of hurting older children who haven't yet hit 18. The internet, its many communities and information repositories are all critical for young people seeking legitimate interest related to sexual health, sexual orientation, and gender identity. Much of this information would fit into the broad definition of sexually explicit material, and it would be illegal for someone to allow them access via the internet. Now, it will remain legal for them to get it in a bookstore or in a library, but that's not how young people generally access information in 2024. And I expect some supporters of this bill will be more than happy to see it limit Canadians' right of access to lawful material that they disagree with. Now, it's good to see a discussion of this important issue. Even if you're in favor of the objectives of this bill, the bill remains deeply, deeply problematic. It should be parked until there's a way to deal with the issue without potentially violating the privacy and charter rights of Canadians. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, please leave a comment if you have any questions or if you have any suggestions for other topics I might cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.